6 o'clock, and we said this meeting would start at 6 o'clock. So I'm going to call this meeting to order at 6 o'clock, and I have the copy of the proof of posting. So would you please acknowledge that? If everyone would rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You will be seated. Good evening, everyone. This evening, we have a grievance hearing that has been scheduled from 6 to 9 p.m. this evening, and we won't go any later than 9 o'clock. If we do need additional time, we'll resume again tomorrow on Tuesday, September 28th, from 7 to 9 p.m. Although this is a grievance hearing and the employee has requested that it be held in public, there will be no opportunity for public input. If the employee has changed his mind in having it public and wishes to go into non-public, we will ask the public to leave the room. Is that still your choice?
Yes, it is.
Okay, thank you. Since this is a grievance hearing, it involves the rights of specific parties, and decisions made as a result of such hearing must be based upon and supports the record developed in this hearing. The Police Commission reserves the right to recess the grievance hearing if the Commission needs to confer with counsel. I have some rules of behavior this evening. Thank you. We expect the public to maintain a sense of decorum. If that does not happen, I will ask the offending parties to leave the room. I ask the public to please refrain from any comments during the hearing, and only those people who are taking part in the proceedings will be allowed to speak. I also have some introductions. At my far right next to me, is Attorney Lefebvre, who will be advising the Police Commission. To his right is the Administrative Assistant, Francine Spofford. To the front of the room, on my right, is Thomas Noonan from the Teamsters. Right next to him is the grievant, Officer Defina. Right next to him is the attorney for the grievant, Attorney Cahill. Across the way is Chief Agrafiotis, Chief of Police here in Hooksett. And with the chief is Attorney Liz Bailey on behalf of the town, the police department. Excuse me. Thank you. We also have rules for the grievance hearing. Although the hearing does not follow rules of evidence procedure, the hearing will be based on offers of proof by the attorney and their clients. The hearing will be divided into two parts. First, we'll take up the issue of due process, and then the issue of just cause. Each lawyer will be permitted to make an argument uninterrupted as to why their client should prevail in this dispute. While the Police Commission will not set any time limits on each presentation, we will ask that each side not be repetitive, and we reserve the right to cut off presentations if we feel they are redundant. After each presentation, the Commission reserves the right to ask questions of any person who has knowledge of the issues in this dispute. The Commission will first hear only the employee claim that he was terminated without being afforded an opportunity for due process. The lawyers are instructed to address only the issue during that initial presentation. The commission will then deliberate and announce its decision on just that limited issue. Thank you. If you would proceed. If you would, please, the mic.
First of all, I'd like to thank the commission for taking this up. I am attorney Bill Cahill for the Teamsters, and also Jason DeFina. And thank you, Attorney Bailey, for the sharing of exhibits, and the chief for also attending. This grievance that was filed after a Hooksett Police Commission hearing that happened on September 8th, 2009. It was a meeting that lasted 8 minutes. That meeting consisted of the Pledge of Allegiance, a reading of a document prepared by a former commissioner, an objection by yours truly as to due process, a request for in writing what the reason for the termination vote was for. And I was told at the time there was nothing in writing that could be given to me at that meeting that lasted 8 minutes or so. I was informed that my option was to grieve it. I was also informed that there would be a grievance before a secondary Hooksett Police Commission to be determined. And as I sat there, not aware of any previous hearing as to the status of Officer DeFina, where just cause was going to be, had been discussed, I was wondering when all the deliberations took place that led to the motion to dismiss, and also led to the legal opinion that a secondary commission appointed instead of the commission that's that did the actual termination, why they wouldn't be having a hearing to go over the just cause. There was 273 of the Labor Relations Act was put in place for the harmonious relationship between public employers and employees. And also within that act is that the contract must have a grievance procedure that is workable. And the only way that that grievance procedure is workable is if there is notice and communication between the employer and the employee. I stand here today still not knowing if one of Jason DeFina's supervisors had a charge against him, or it was the chief, or the chief was going off the opinions of one of the supervisors, because the P-250, the Hooksett Police Department form P-250, which is what the department uses from anything from accommodation to termination, which kind of sets up the notice that something's going to be put in this personnel file, was never filed in this case. On August 26th, the chief wrote a memo to the Hooksett Police Commission that when we were sitting there on September 8, 2009, we did not have a copy of that, nor did we have knowledge of that being produced for the commission. In fact, we did not even get a copy of that particular memo until after the unfair labor practice, which was sometime later, was filed. So our biggest concern about the due process was the fact that there was no communication between the employer and the employee as to the fact that what the charge was that he was going to be terminated for. He didn't have an opportunity to defend himself or give testimony or evidence or offer proof before the commission prior to them taking the vote. And this is not the first time that the Hooksett Police Department has terminated a police officer. This isn't the first time I've been involved in that procedure. The way this particular proceeding went down was nothing akin to my 26 years in the Mass State Police, my 14 years as a labor attorney. I have never seen a process where an officer would be blindsided at the appointing authority's hearing. And I asked on behalf of my client that he be reinstated because he was not afforded due process. And technically, this should be brought back to step 2, to go to the person that, if there is a charge against him, under the contract, he has the right to sit down with that person and talk about it and agree with it, and then it goes up through the stages. It goes to the supervisor, to the chief, then to the commission. If in fact the commission, if the department's position is, we didn't fire him, the commission did, well then you have to look at the law, and the law states that a due hearing has to take place prior to termination for cause. And I have no record of any hearing of what took place that would justify the termination of Officer DeFina. So I guess I have actually more questions than I have facts, because it is our position, the team's, is that there was no hearing on the facts. There was no due process, there was no notice to us. He was notified approximately a week before that he had the right to appear at a meeting, a non-public meeting, that the Hooksett Police Commission was holding. He wasn't ordered to show up. He wasn't told that there were charges pending against him. He wasn't told in particular what those charges were. And we did show up to that meeting, and we left, as we came in, empty-handed, because there was nothing. We asked for documentation, we received none. And as you can see, during a normal hearing process, the amount of paperwork that is produced. In a normal hearing procedure, the parties, including the attorney for the Hooksett Police Commission and Attorney Bailey, we generally have a lot of interaction and exchange of exhibits. That never took place.
That you were never notified about the meeting. How did you know to go to that meeting?
I think I just stated that Officer DeFina was notified by the chief that he had a right to go to a Hooksett Police meeting, a non-public meeting, for 9/8/2009. Now, as you're well aware, that if that was going to be a hearing, whether it was public or non-public was actually up to him, not up to the commission. So he called the union saying, and obviously he's sitting right here, so you can ask him, but he called the union stating that they're going to talk about my whether I'm going to be terminated or not, and that's all the information he had. Now, generally, when someone's going to get terminated, charges have been preferred by someone, the supervisor. It's been endorsed by the chief, or there are charges put forth by the commission, and then if the Hooksett Police Commission wants to prefer charges, then they have to hold a hearing and give them an opportunity to discuss what charges specifically are being lodged against him.
I understand that, but when he was told about the meeting that he could attend, was he told that the meeting had to do with his termination, or it was after that? Because 9/8 was?
Well, I hope he wasn't told it had to do with his termination, because that means it would have been deliberation
What was he
time.
told specifically, if I can ask Officer DeFina, what were you told specifically about that meeting that day?
Do you want me to read it to you?
Much
I have
yeah.
it. I was called into a 45-second meeting with Chief Grafiotis. Officer Lori Stoll was there, Lieutenant Klein was there. The chief came in, sat down. He said, "I'm supposed to give you this. It's a copy of a non-public meeting on the 8th at 5:30. He handed me, can I have that piece back? This notice says, "A non-public meeting of the Hooksett Police Commission is scheduled to be held on Tuesday, September 8th, 2009 at 5:30. For the purpose of discussing a personal matter pursuant to RSA 899. Then he said, "I'm supposed to tell you that the commission is going to be meeting that night to discuss your possible termination. I'm supposed to tell you that you have the right to attend the meeting. Tom Noonan will be informed if he hasn't already. If you have any questions, Tom will be the person to contact." Then he got up and he left the room. It took 45 seconds.
What was the date of that?
That was on 8/31/09.
And who was the other officer that you were referring to?
Officer Lori Stoll, she was my field training officer.
Lloyd who?
Lori Stoll,
Oh, okay,
yes.
thank you.
At that, on 8/31/09, when you were informed by the chief, were you informed of what, any charges that are being brought against you?
Nothing, exactly what I read is the only communication that came back. Came in, sat down, said it, got up and left.
Were there any forms given to you?
Just this, ma'am.
Just that?
It's just the notice that was posted.
And does it say, can I see?
Yes.
Yes, you may.
Do you have copies? You have copies?
Yes, yes, sir.
Attorney Cahill, given your experience with these types of things, how do you feel it should have gone with regard to this process?
In order to be informed of what the problem is. As I mentioned, there was a memo to the Hooksett Police Commission penned by the chief on August 18th, I believe, or was it the 26th? 26th. And the CBA, the contract, states that, and I'm paraphrasing, 6-3, but if the chief or his designee has an issue, a complaint, either external or internal, he will investigate same and then notify the officer within 7 business days. Why the officer was not notified of some complaint, I have no idea, but the due process of notifying the officer of the complaint was not complied with when he sent that forward, and he's referring to issues that were 2 weeks prior to that. In my opinion, if he did an offensible, if he committed an offense in the chief's mind, or Lieutenant Klein's mind, or Lieutenant Captain Cecilio, normally they would write up a charge. The employee signs that, not admitting that he did it, but admitting that he's been informed that this charge is pending. And that sets forth the process for him to contact the union and for us to start gathering evidence.
And that wasn't done in this case, is that what you're saying?
There was no P-250 filed in this case.
And he was terminated on when?
We showed up 9/8. We were there for 8 minutes. Commissioner, chairperson at the time, Gagnon, read a document A vote was taken, I objected, I was told I could grieve it, and the vote was passed 2-1, and he was dismissed.
That document that he read, did that state what the charges were against the officer?
It's stated, it referred to what I believe was the memo that the chief sent to the commission. But
Is
was
it a
not
memo,
some- I'm
is it a
sorry.
memo or a letter? I don't quite, you said letter at one time and then you say memo now. Was it a letter or a memo?
You talking about the one the chief
Yep.
sent to the commission? It's on department stationery dated August 26, 2009, and it's addressed to the Hooksett Police Commission, and it says, "Dear Police Commission," and then it's signed by the chief.
So it is,
So, it's, whether it's a letter or a memo, it's not a personnel letter or anything like that, but it is a correspondence.
and it's on what kind of stationery? It's on the chief's stationery?
That's affirmative, ma'am.
Okay.
And did that memo from the chief on the 26th to the commission say what the recommendations of the chief were in regards to any discipline to him? And what the charges might be?
Better still, is there one in our,
Yeah, it's tab 3.
okay. Just to
And-
make sure that we're following along, you know, even though we're trying to follow along. Would you please point that out to us, for those of us who are not always that quick?
Will do.
Okay, thank
It's
you.
on page 30. And it does talk about the FTO training that he was in. And my point is this, is if we knew that this was an issue that he was gonna be terminated for, then we would have had a hearing, and he had the right to a hearing, to talk to the field training officers, to talk to the people involved, and see who in fact was stating he wasn't cooperating. Because in tab 12 has all the daily observation reports of Officer DeFina done by the field training officers. But that's going beyond the scope of the due
Yes,
process.
I was gonna stop you.
Thank you.
Okay, thank you. You all set?
No.
Okay. Go ahead.
Thank you. My name is Liz Bailey, as you've introduced me, and it's my privilege to represent the Hooksett Police Department.
Okay,
I
thank
thank Attorney Cahill, as he has thanked me for sharing evidence in advance of this hearing. I am mindful that you have ordered the attorneys to confine themselves to the due process issue. I would ask, however, that the commission please be open to hearing all the evidence in this case for a couple of reasons. One, as I understand it, and I'll go into the due process claim in a few minutes, the due process argument does entail essentially the union saying that ultimately they should be heard by this commission as to the substance of this issue, whether or not Officer Jason DeFina should be reinstated. So we do ask that you hear all the evidence, because it's an issue that, to understand thoroughly the due process issue, you will need to have a greater understanding of the background between the parties. The other reason that I do ask that you hear evidence related to issues concerning Officer DeFina's performance is that it goes directly to one aspect of the due process grievance, and that is the issue of reinstatement. So I would ask the Commissioner's indulgence to be able to hear out the police department tonight in its presentation of evidence. And I'd like to just start out by going backward and framing the issue if I could.
If you would hold on.
Sure.
I think we stick with the due process. I don't want to hear anything about merits until the appropriate time.
Okay. I think for the Commission's point of view, that before we came here this evening, we had already decided, and you understood the direction that we were going to take with regard to the hearing this evening. And even in spite of what you just said, I think there still is the same feeling that we want to continue and do the procedural first. So we're going to go that direction.
Thank you, Commissioner McHugh. I would like to just, in my presentation, try to take a step backward, though, and try to give you a context, because it is important for the due process issue just to understand the context of how the parties found themselves at the September 8 meeting. And I don't think you have that at this point, so I will try to move right along.
But the context is going to be, if I can interrupt you, the context is going to be just about the process of what was brought forward by the police department, because if you go backwards into any other prior discipline, any other actions, that would be inappropriate at this time, because we want to look at just a due process issue.
Why don't I try to proceed, and then to the extent that I'm saying something that you feel is inappropriate or that you don't want to hear, you can let me know that.
I think you need to proceed very, very carefully, because as I just said to you, we were very, very specific about how we were going to go about this, and I understand what you're saying. However, I think from the Police Commission's point of view, and in order to set aside the issues and to completely understand them, we've chosen to go in that direction. So please be very, very careful, because you're going to get stopped and you're going to have to cease at that point.
All right, let me just try to focus ourselves on why we're here tonight concerning the due process grievance. The due process grievance you will see at page, at our exhibits, the big binder, if you will. And what I will do, just for the record, is our exhibits do have page numbers on the bottom right-hand corner, so they're sequentially numbered. And I'd just like to direct you to pages 39 and 40. It's Hooksett Police Department Exhibit G, and that is the second grievance, actually. The first grievance was about just cause. This is the second grievance filed by the union, and it's about...
Why are we hearing that?
We're not.
We're hearing the grievance at this point about due process.
That's what I'm referring you to, sir.
That's not what you just said. At least that's not
That's
what
what
the
you
way I
said, the
understood
second.
it. I
This
apologize.
was the second grievance, in fact. It came second in time, but it is the due process grievance.
I don't think they really, it came second in time. Actually, I think they both came together.
Okay, I'm just referring to
Is
the
that,
sequential numbers.
I think that's the way this all went down.
Well, if I could refer you to pages 39 and 40. And that is the due process grievance that you're being asked to hear tonight. It does ask, as you've seen, for the commission to find that there's been a violation of Article 18 of the contract. And I'm sorry, if you're needing time to find that, please let me know.
Page 40.
40, yeah.
Are you all set?
Hang on a moment. Yeah, let's see.
Commissioners, are you all set?
I'm getting a little confused, if I can say that, is we're moving into just cause according to this exhibit that you're sending us to, that talks about discipline and discharge, and it talks about the just cause
Right.
issue as opposed to the due process issue. So when I look at that, and you ask us to look at that, it seems that we're moving into the just cause aspect, which is the discipline, as opposed to due process. Was due process afforded the employee?
And for the record, Commissioner Carolian, what I was referring to was simply the underlying grievance that the union initiated concerning the due process issue. This grievance is in the words that the union has chosen to write concerning that grievance, and I was simply trying to direct your attention to it. On HPD 40, you will see that the union alleged the Hooksett Police Commission violated this article, that is Article 18, by terminating Officer Defina with lack of due process and a failure to follow Article 18 of the collective bargaining agreement. So you are correct in saying that Article 18 does deal with discipline and discharge and just cause. What we are here for tonight, ultimately, is a grievance proceeding under the collective bargaining agreement. And that in turn requires you as a commission to make a determination about whether or not that article of the agreement has been violated or not. So you really are not able to make that determination without looking in the first instance to the language of the contract. So what I just pointed out to you, sir, was simply the grievance as the union chose to word it.
I understand that, but I still think that we're on a due process issue, and whether it's in the contract or not, whether it's in a collective bargaining agreement or not, it's my understanding that due process still has to be followed.
Commissioner Carolian, I do understand your position, and I'm just simply trying to move on to the language of the grievance itself.
Well, then, let's move on
Sure.
and do the due process part of it and save the just cause for later on, okay? If you would?
I will try to do that.
Thank you, I appreciate that.
You're welcome. What you do need to determine, though, in order to adjust this grievance, even as to the due process nature of it, is still whether Article 18 has been violated or not. That's the question before you.
I don't think so at this point. I'm looking at whether due process was followed. Regardless of what the charges are, the employee still has to have due process afforded by the employer. And that entails certain things according to, which I'm sure you're aware of, the Loudermill decision?
I'm aware of that.
Okay,
Thank
so
you.
that's what I'm looking at.
And perhaps Attorney Cahill can clarify that I correctly stated the nature of the grievance that you cited? You filed?
I didn't file it.
Have I correctly stated the grievance report?
That's filed by Jake.
Thank you. Again, I would direct your attention to Article 18 of the collective bargaining agreement. You're going to find that in our Exhibit A of our materials. And Article 18, which is referenced in this agreement, is found at HPD page 19. That sets forth what you need to take into account to determine whether or not there's been a violation of Article 18, which is ultimately the question set forth in this agreement. And you'll see the language there before you. To give you a background concerning the process here, clearly if you look to the language of Article 18, it has been complied with, because Article 18 envisions that just cause for discharge shall exist if the chief determines that there is unsatisfactory performance or misconduct by Officer Defina. And we have heard evidence tonight that the chief did make that determination that just cause existed for Officer Defina's discharge in his August 26, 2009 recommendation. That you're going to find in our exhibit books at HPD E, which is at page 36, HPD 36. And in that recommendation, I'm not reading all of it, but Chief Agrafiotis found, based on the totality of Officer Defina's personnel history over the years, the results of his latest evaluation, and his failure to cooperate with the department's
I'm
attempt
going to
to...
stop you again.
Yeah.
We continue to go to the just cause and not the other, the due process. And I know what you're saying to us, but I think the commission has said repeatedly that we want to deal with that, and I know you're saying, or at least I surmise what you're saying, that the fact that he did this means that he's followed the due process.
I'm saying that is a part of it, and I would just ask if I could be able to discuss that document briefly, because it's in your exhibit books and because it has been referred to by Attorney Cahill. I think one of the concerns I have is that you are going to be in a position, or to put you in a position to understand the context of things. We've heard reference to that recommendation, and I was simply trying to elaborate on what you have already heard offered by the union. I would ask your leave to do that.
So if I understand you correctly, you want us to look at HPD 36, which is the letter dated August 26, 2009, from the chief of police to the police commission, making his recommendation for termination.
If you could, Commissioner Crowley, thank you.
Okay, but that's what you're drawing our attention to.
Right.
Yes, sir.
Okay, so we understand that that was done. It's dated, it's sent. What we're concerned about is the due process. I don't know how many times we can say that. It's the due process of how the employee was terminated.
And I understand that, and I'm simply trying to tell you about the same evidence that you were at least referred to by the union's attorney, and I would just ask you to do that. But to understand the due process, you've seen that letter before you, you can see the chief's recommendations and the nature of them. I do need to talk about how we did get to that September 8 meeting. And you are probably well familiar with this, but to give some background, under the statute that pertains to the police commission, the commission has the power to remove police officers for just cause. You'll see that reflected in HPD Exhibit B, which you'll find at pages HPD 32 of your materials. And under the police department's own rules, the police commission has the right to immediately discharge a police officer's employment at any time for just cause, and to discharge employees without resorting to prior disciplinary measures. You'll see that at HPD Exhibit C, which is at page HPD 33. And I've already discussed a little bit Article 18 of the parties' collective bargaining agreement, which provides that for purposes of the agreement between the union and the police department, that just cause is what is the chief determines to be unsatisfactory behavior or misconduct. We've talked about how he made that determination in this case. So what we have is that in July of 2009, Officer DeFina received...
Don't go there.
Don't
go there. I understand the point that you're trying to make. I understand we're not arguing just cause. I understand that the chief should not recommend anybody for termination without just cause. We understand that. We understand what our role is. What we also understand is that there has to be due process in order to do that.
And I was not going to talk about that evaluation based on your request, but I'm...
What evaluation? See what I mean?
Yeah. We find ourselves at the September 8, 2009 meeting, and it's important that you do understand how people got there.
The way to understand that, I don't want to be argumentative, but the way to understand that is that we follow due process to get to the termination date. I understand that.
I'm trying to get to that, sir. And I appreciate your instruction. The September 8 meeting happened as a consequence of the fact that on August 18, 2009, Officer DeFina, at his request, met with the police commission to discuss the evaluation that he received. And what happened in that August 18 meeting was that the police commission heard from Officer Defina, they heard from Lieutenant Klein, they heard from Captain Cecilio, they heard from Chief Agrafiotis about Officer Defina's evaluation. And they asked questions of him, they asked questions of Officer Durkis, who was his field training officer and who was there at that meeting. And what happened as a consequence of that was that the police commission grew concerned that they felt that there was an issue that needed to be addressed concerning Officer Defina and concerning his performance, concerning his cooperation in the training program that he had become a part of following his July 9, 2009 evaluation.
Do you have those minutes? Are those minutes included in the,
They are included in the union's exhibits, ma'am, I believe, at Union
that
Exhibit
refer to
16.
that meeting
Yes.
of August 18?
Yes. And I
Did you
believe,
direct me to?
and if I could direct your attention, Commissioner McHugh, to Union Exhibit, it's 16, but it's found at page Union 110 in the binder.
Okay, thank you.
Thank you. And as a consequence of that meeting, the commission learned information was brought directly to its attention about Officer Defina's performance, about issues with Officer Defina's performance, about whether or not he was cooperating in the field training officer program, and you'll see in the minutes as well that it was indicated that he was playing games with staff, he would not sign off on the FTO program, and he commented, and there was a comment that,
We're going right back.
I'm sorry.
We're going right back where we were. Please,
Okay.
please stay away from that. Can I ask you, you were speaking about the chief's statements. I don't see any statements by the chief there, though, that meeting.
It was redacted.
Yeah, I think that's me
So-
that they redacted.
so essentially, there was a meeting at which information was relayed to the police commission, and they were trying to address that information.
Was the officer present at that meeting,
Yes, he was,
the entire meeting?
not for the entire meeting.
How come?
He was asked to excuse himself by the commission so that his FTO officer could be questioned. Following that meeting, Chief Agrafiotis was solicited by the commission to,
Can we back up
Yes.
again? At that meeting, did the chief make any statements whatsoever? I don't see any here, but did the chief make any statements, or were there questions from him, or was only the statements of the lieutenants and the captain?
and I will do my best to answer your questions. I
Okay.
believe the crux of the meeting was Officer Defina addressing his personnel evaluation line by line. Lieutenant Klein providing a chart to the commission concerning the year in review with Officer Defina and being asked questions about that. Captain Cecilio also making statements.
I'm going to have to respectfully object.
I- I'm sorry, I'm just trying to do the best to answer the question, and
Due process would dictate, if something came out of that meeting, who made the charge, how did the officer learn about the charge? We don't have to go into what was said and by whom, and then not even, Officer Defina was not there when the lieutenant, the captain, and some other people testified. He had no way to defend himself. He has no idea what was said when he wasn't there. It does not, as far as that goes, that would go to due process, but I don't think that's the point that they're trying to make.
Commissioner McHugh, I'm just trying to answer your question, and I actually thought I would have the opportunity to present. Coming out of that meeting, the chief was asked for what was his recommendation concerning the situation that was discussed at that meeting. That he provided, as you've seen, by HPD Exhibit E, the August 26, 2009 recommendation.
Well, why wasn't there, what I asked you a couple of minutes ago, in the minutes, there doesn't seem to be anything, any statement by the chief at all here. But then you're saying that subsequent to that, that's when he wrote the letter?
Yes,
But he made no statements at the meeting?
I don't,
Well, there aren't any. I'm looking through, there's a section that's redacted, but I don't think it's the chief speaking there.
The minutes certainly, I don't think, are a verbatim recitation. of
Certainly
everything that
not,
was
certainly
said.
not, but I would think that something like that would certainly be important.
And
Okay.
I certainly think that, apparently I can't discuss the substance of that meeting, but I think the evidence would reveal that Officer Defina's performance was discussed at great length at that meeting by Officer Defina himself and by Lieutenant Klein as well. So, coming out of that meeting, the chief was asked for his recommendation because the commission was concerned about the information that it had received at that meeting. And the chief gave that recommendation. From there, what happened is that Officer Defina was, as you've already heard, afforded due notice to be heard. The commission noticed the meeting for September 8. It was clearly as to a personnel issue. The commission, in fact, provided ample notice to the union and Officer Defina that the hearing was going to take place. You have heard the testimony from Officer Defina that Chief Agrafiotis provided him with notice face-to-face that the meeting was going to address his potential termination. That happened a week in advance of the September 8 meeting taking place. And now we turn to the September 8 meeting itself. And if I could ask you to turn your attention to exhibit,
I'm sorry,
yeah, sure.
if you don't mind, I'd like to go back to these minutes of August 18th. Who redacted those minutes?
That was an exhibit that was prepared by the union or a joint exhibit by the union and the police department at the PELRB hearing.
Were there any other statements or,
Anything that I have for exhibits, except for the contract, came from the police department. I made no alterations whatsoever.
And as I said to you, Commissioner McHugh, that document was used as a joint exhibit at a related PELRB hearing. So that's how it appeared at that hearing.
I'm sorry to hold you up, but I just need some clarification. We're talking about the grievance exhibits here, okay? And for the meeting of August 18th, on that page 111, there's a certain section that's redacted.
Yes, Commissioner McHugh, and that is the exhibit submitted by the union tonight, and that was how that document was submitted at the PELRB by agreement of the
I can
parties.
appreciate that, but I'm asking, does anybody know what was,
The original minutes themselves that would be on file with the Hooksett Police Department would be without redaction.
the reason why I keep on asking, because you referred several times to the fact that the chief was asked, you know, at this meeting, when they were talking about the evaluation, and the chief certainly had some comments, and then he came back subsequently and produced that letter of August 26th. But I don't see any statements in there at all from the chief. And like I said, I just wondered why there was a certain section redacted. Go on, thank you.
Thank you. So going into the September 8 meeting, Officer Defina is on notice of the meeting. He was invited to attend. His union representation was invited to attend, and he did understand that it related to his potential termination, and he understood that a week in advance of the meeting. He was provided notice to be there, he was provided an opportunity to be there, and he had ample opportunity to be heard about a potential termination. Now I would like to turn to the events of this
I
attendee meeting.
have to object that he was able to be heard. When I was sitting at the police commission hearing, and I was told at that, it was a meeting, I wasn't allowed to say anything, and I was told by Attorney Higgins I could grieve it for the unit.
Let me ask you this, Attorney Bailey. I want to try to simplify it, and it should be
Sure.
fairly easy to do. When was the employee notified as to that he's subject to possible termination by the department? What was the date?
He was notified that he was subject to possible termination by the department on August 31st, 2009, when he met with Chief Agrafiotis.
Was he told at that time by the chief what the charges are against him?
No, he was not.
You know, after that, there was another meeting.
I'm referring to the September 8 meeting at this point, if I may, unless you have another question, Commissioner Carone.
It has to do with sequence. And what I'm
Sure.
looking at is, from what I'm hearing you say, the chief on the 31st of August, '09, notified the employee that he was subject to termination.
That there would be a discussion by the commission of his potential termination at the September 8, 2009 meeting.
But he wasn't told what the charges would be.
He was not, the charges were not detailed because, as we have seen, or we're about to see, the motion came from the police commission. And within that motion, the charges were very detailed.
Okay,
Could I turn to that now, or would you
well,
like to?
no, I just want to get to make sure that we follow the
Sure.
pre-termination hearing that he's entitled to. At what stage and what date was he provided with a pre-termination hearing? The informal hearing that he knows what the charges are, he's told what the charges are, and that he gets to refute those charges. Not a full evidentiary hearing or through the grievance process, but under Loudermill, where he gets some sort of letter, notification, what his charges are, and that he's entitled to have a pre-termination hearing.
That occurred on September 8, 2009, which I was just about to get to, sir. Could I turn your attention to Exhibit D in our notebook?
Sure.
Chairwoman McHugh, if I may, before we start getting into the just cause, where it seems to be slipping, could we please see the notification in writing that notified the employee what he was about to walk into? Because I haven't seen it to this day.
Well, I believe, if I'm correct, that you said he was told
That is correct.
by the chief.
That is
And
correct.
did I hear you say previously also that there was someone else also there?
Actually, Officer Defina has confirmed all of that information earlier.
I'm asking you the question.
Yes,
Who else was there?
Chief Agrafiotis, Lieutenant Klein, Officer Defina, and as I understand it from Officer Defina, Officer Stoll.
Lori Stoll.
Yes.
And what was the date that he initially went to the commission because he was complaining about his evaluation?
Yes, that was, as I tried to allude to, that was August 18, 2009.
And out of that, he was asked to leave the room. He was not allowed to stay.
He stayed for the vast majority of that meeting.
But was he told to leave the room and witnesses were brought in from the department?
He was asked to leave the room, and Officer Durkis was brought in, and there were questions asked of Officer Durkis.
Do you know why, or can the chief explain to us why he was asked to leave the room?
I believe that it was at the commission's request, so I can't answer that question for you.
That's correct.
The commission requested him to leave.
And I would also add that it wasn't just us, the FTO that was asked to come in. Lieutenant Klein and Captain Cecilio also made statements while after Officer DeFina was asked to leave the meeting.
So,
Getting back to that notice, isn't it customary that someone be handed something in paper form as opposed to just verbally?
There was a written motion made.
No, getting back to, and I think this is where a lot of discussion has come up, about on August 31st, when he was told by the chief about the upcoming meeting, okay? Isn't it customary that you would hand someone a notice advising them as opposed to, just verbally making that known?
There have been times in the past where paperwork has been provided to the employee. There's been times when people have been subject to verbal counseling. I was trying to explain the background of this and to put it into some context, because due to the fact that this information that prompted the September 8 meeting was something that came about at the August 18 meeting, information that was presented to the commission. This was somewhat of an unusual situation. This was a situation that was different from what had happened in the past, in that, in the general sense, information hadn't been conveyed directly to the commission, including meeting with the employee as it happened on August 18. What happened on September 8, if I could return to that, is that after Officer DeFina was notified a week earlier that that meeting was going to address his potential termination, the meeting occurred, and at that meeting there was a detailed motion that was read into the record. And a copy of that motion was later given to the union. That would appear at HPD Exhibit D of your materials, HPD 34 and HPD 35. And in that motion, it was very detailed as to what the basis was for why the commission was moving to terminate his employment. I'd like to read some of that motion for you.
I have a quick question for you.
Sure.
Actually, it's for the chief.
Excuse me, Commissioner?
No. This is for the chief. And we're going back to that commission meeting where he was asked to leave and that you had presented evidence to the commission. Isn't it customary to present the evidence to the commission at the proper time of the grievance, as opposed to presenting the evidence to the commission prior to the termination? Because the commission would, you would make a recommendation for termination for just cause. Understood, that's what your job is, that's fine. That would go to the commission and go through the proper steps, and then that evidence would be heard by the commission for just cause, as opposed to doing it backwards and presenting information to the commission.
Commissioner, you're correct. However, that's not the way the sequence. The meeting that you're talking about was not a termination hearing. It was a meeting where Officer DeFina had requested to speak to the commission to voice his displeasure at the evaluation he had received.
Okay, that was on the 18th?
Yes.
Why does it say
look at the
here,
minutes.
evaluation for termination? Why does it say that in the minutes? That Captain Cecilio stated that Officer DeFina was given the evaluation for termination. I don't understand that verbiage.
And I'm sorry, if you could, humor me a little bit reason why I was trying to talk about things in more detail was to try to put some of these things into context for you so that it would be more understandable.
But-
The August 18 meeting was at Officer DeFina's request and to address his performance evaluation that had taken place in July of 2009.
Okay, so months, the months earlier. We're talking,
1 month
this was
earlier,
1
sir.
month prior, right?
Correct.
Okay, and then he's kicked out of the meeting.
I would disagree with that characterization.
He was told to leave?
Respect. He was asked to excuse himself.
He was ordered to leave? Was he ordered to leave?
Commissioner Gagnon asked Officer DeFina to leave the meeting.
So he was ordered to leave the meeting. And then information was brought forth to the commission
That is correct.
without the employee having an opportunity to answer and rebut anything that's being brought. And that's my question to the chief, is this information was given to the commission prematurely. Because the commission's job is to sit and listen and go through the procedure and make sure the due process is followed as well as the grievance is being followed. And from what I'm hearing from you and from the chief, that doesn't seem to be what had happened. And I want to clarify that before I come to a judgment on that.
Certainly, and I think the chief said that very well. That gathering was not a grievance hearing in any way. The chief was not there making any recommendation. The August 18, if I could just finish, the August 18 meeting was for the purpose of hearing information at Officer DeFina's request.
But he
about his
wasn't allowed to
evaluation.
hear all the information. By the sounds of it, it sounds that he was asked to leave, and then more information was brought in by Lieutenant Klein and Captain Cecilio, I'm assuming at the request of the chief. Did you ask them to come in and give this information?
Yeah, I might add, Commissioner Crowley,
I
I
asked
think
the
there's
question.
a confusion. Yes,
I asked the question.
The commission chairman, Dave Gagnon, had asked that the people involved in preparing that evaluation, which were Lieutenant Klein and Captain Cecilio, be at that meeting to potentially answer any questions that the commission may have of them, reference the evaluation. After Officer DeFina gave his input as far as his displeasure with the evaluation, the commission, at that time, with Officer DeFina present, started asking the people that prepared the evaluation their input as far as the points of disagreement within the evaluation. Commission at some point became concerned about the answers they were receiving. They were hearing information, as I was for the first time, about Officer DeFina's behavior. At a certain point, the chair asked Officer DeFina to excuse himself from the room, and Officer Durkis, who was the primary field training officer for Officer DeFina at that point in time, was brought into the room, and the commission started asking Officer Durkis questions, which they received answers to.
Did you object at any time and notify the commission that what they're doing is improper at that point?
No, because at that point, they were trying to vet out, if you will, the comments that were made by Officer DeFina, by the supervisors that had prepared the evaluation, and what they were reading in the evaluation. They were, if you will, in a fact-finding mode about the evaluation itself.
Okay, I understand.
Now, I just heard you say that was the first time you really, at that meeting on August 18th, that you really had knowledge about Officer DeFina and what both Captain Cecilio and Lieutenant Klein felt about his evaluation?
No, that's not correct. I had
Correct me then.
information about what was in the evaluation. There was other information, as you may remember, that came out during that meeting that I did not have information and would not have been included in the evaluation anyway. That information came to the commission's light as responses to the commission's questioning of the people that had put the evaluation
So you
together.
knew of the evaluation, but there was some other information that you weren't aware of?
That's correct, and we all learned at that night.
And that was the officer that they asked to come in?
It was from, the field training officer was primary information, and I believe there was other information given, and you were there, from the captain and the lieutenant. That
Okay.
was that was not in the evaluation, and would not normally be in the evaluation.
Okay.
My question is why was that allowed to occur?
Please do bear in mind, this was not any sort of grievance hearing.
I understand that, but
And I think that, as the chief had said, people were there to try to answer questions about the performance. The commission, sitting at that point, did want to hear from an officer, and they did. And stated simply, that was how that gathering went that night.
I understand that.
Okay?
I'm just questioning as to why the commission had heard that.
And Commissioner
not their
Carlin, I simply do want to bring to your attention, I might be reiterating this, but that was not a grievance hearing. There was no recommendation pending concerning Officer DePina beyond the discussion about his evaluation.
But it was a disciplinary action, right?
No, that meeting was not a disciplinary action taking place.
Well,
That meeting was to discuss, at Officer DePina's request, his evaluation.
okay, but
Would I be able to return to the September
in
meeting?
just 1 second, because I want to make sure that we cross our Ts and dot our Is here.
And again, I apologize. My thought had been in trying to inform the commission about the July 2009 evaluation, to try to fully inform the commission about the events between then and the August 18 meeting, and then to try to fully inform you about the events leading up to the September 8 meeting. I could put all of this in proper context for you. That's why I was seeking to do that earlier tonight.
All right, at the August 18th meeting with the police commission, if it didn't involve any type of discipline, why do the minutes read that Captain Cecilio stated that Officer DeFina was given the evaluation for termination by Lieutenant Klein?
Because that's a simple recitation of
But-
the evaluation that Officer DeFina wanted to review with the commission. You have not allowed me to discuss that with you tonight, so I haven't been able to elaborate on that evaluation for you.
Are you telling us that there was a recommendation for termination before the 18th, and that Officer DeFina was going forward to the police commission to go forward to the police commission in regards to his possible termination? Because that's,
No, Commissioner
clarify it
Rowland,
for me.
I'm not. That's why I wanted to address the evaluation of July 13 with you.
does the evaluation of July 13th involve termination recommendation by Lieutenant Klein?
Yes, it does. You'll find that in Exhibit M in your materials.
So then the commission would know that the officer is coming forward in regards to possible termination?
No,
I don't understand.
that's
If
why.
if the employee was given an evaluation recommending termination, how does he go in front of the commission on August 18th and we say that it's not a discipline hearing, but yet he wants to come forward and discuss his possible termination? I don't
No, I
understand.
think the confusion is perhaps created here by the commission's unwillingness to review the personnel evaluation itself. You'll find that in HPD Exhibit M, HPD pages 393 through 402. In what had happened, and you'll find it at pages 401 and 402, Lieutenant Klein had recommended termination. Captain Cecilio had recommended termination on account of performance problems that Officer DeFina had demonstrated over the past year, significant performance problems.
How's this due
I-
process? I'm really sorry.
I understand that, and I'm going to move it forward too. How does that information come into play the August 18th, and we have the official minutes, that this is not, that August 18th meeting was not, according to what you're saying, was not involving any type of discipline, when you have a recommendation for termination prior to that, and that the employee is coming forward asking to speak to the commission about his evaluation, but yet, if you're telling me that in his evaluation was not a recommendation for termination, then there's something wrong. If there was a recommendation for termination, then that meeting that was held on the 18th would be a disciplinary hearing. It would be a disciplinary meeting, and the commission would have heard disciplinary issues about the employee without having, one, the employee there, other than to give his objection and then ordered to leave, and then the commission turning around and deciding without a hearing for the officer to have a due process hearing. That's the crux of this, I think.
No.
It's not?
No.
Explain it to me, please.
I would like to try.
Without going into just cause.
You'll see at page HPD 402, we simply hadn't been allowed to finish the chain of events, sir, that although Lieutenant Klein made that recommendation and although Captain Cecilio agreed with it, ultimately Chief Agrafiotis declined to accept that recommendation and ordered instead Officer Defina to undergo a modified training program. So the August 18, 2009 meeting, and I don't think the union would disagree with this, was at Officer Defina's request. The police department didn't ask for it. There was no pending termination recommendation at that point because Chief Agrafiotis had decided not to agree with that recommendation. And that meeting was to discuss Officer Defina's personnel evaluation. When you look at that personnel evaluation, it does contain all of that information that we just discussed. So it was not a disciplinary hearing in any way, and I don't think any of the parties thought it such.
Okay, so when did, in your opinion, when was Officer Defina, one, advised of his charges, two, offered a pre-disciplinary hearing, and three, being given the charges? When did that occur? Because that's really the narrow scope of what we're looking at.
I do understand, and I had been just about to get to that when we had some other questions and discussions, Commissioner Carolian. As we've discussed, Officer Defina was notified of the September 8th meeting concerning potential termination on August 31st. The September 8th meeting, there was a written motion read to the record which set forth in great detail the basis that the commission took for determining that it thought that Officer Defina should be immediately terminated.
So
yes.
if I can interrupt you, that's where I want to focus a little bit on, is that 9/8/09 meeting where the commission has already decided that they're going to terminate him. Is that correct? At that meeting, they decided they were going to terminate him?
There was a motion read, which I'm directing your attention to at pages HPD 34 and 35. And Officer Defina was given an opportunity to say anything he wanted as to the substance of that motion. And what happened was Attorney Cahill objected on the basis of due process, but there was no other information given by Officer Defina or the union.
Okay, on the 9/8, that motion that you're
Yes.
talking about,
Yes,
was it the commission's opinion at that time that they were terminating him at that meeting?
the motion was made, he was given an
Motion
opportunity
was made for what?
for termination.
So there was a termination decided on 9/8.
Yes, ultimately.
Prior to that, was he read what his charges were?
Prior to that, there was no writing exchange to Officer Defina concerning the basis of this motion.
So in layman's terms, no?
However,
I need an answer because I need
Yes.
to know.
I think I've answered that. There was nothing in writing provided to Officer Defina concerning the commissioner's analysis about whether or not termination was warranted prior to September 8th. On September 8th, that information was fully read into the record. Please do bear in mind a couple of things. That there had been a history that I understand that you don't want me to go into today.
Regardless of what his history is,
No,
was he told prior to 9/8 that what the charges are against him, and was he afforded a pre-termination hearing? That's all we want to discuss.
He was told on September 8th what the basis was for the motion for termination. At that hearing, he was given an opportunity to say whatever he wanted in rebuttal to that.
That was after he got terminated by the commission?
No, that was before the motion.
Before.
Before the motion.
So at
was-
that meeting on the 8th,
Yes.
they told him, we're going to terminate you.
They read the motion into the record.
What did the
which
motion say?
I'd love to tell you. It reads as follows. The Hooksett Police Commission will now take up the matter of Officer Jason Tapina and specifically determine whether or not he should be terminated pursuant to the authority conferred on this commission by state statute and recognized under the department's standard operating procedures. This matter has been duly noticed for a non-public meeting pursuant to RSA 91A:3, Roman 2A. Officer Tapina is represented by the Teamsters Union, Local 633, which is a party to the collective bargaining agreement with the department. Article 18 of the agreement provides for discharge for just cause. Those words are defined to include, in part, unsatisfactory performance as determined by the police chief. We have recently met with Officer Tapina at his request to review with him and other members of the department his performance evaluation for the period June 1st, 2008 to July 1, 2009.
Do you know when they recently met with him, what the date was?
Yes, that was the August 18 meeting, Commissioner Crowley. His scores, to return to the motion, his scores ranged from average to low, and Lieutenant
Okay.
Klein,
We don't need to get into the actual just cause. What we need to keep is the first part here.
I do understand, but you had asked me what notice he was provided of,
Right.
and this is that notice.
Okay, and I'm concerned with the due process.
I do understand that this is the notice that you are trying to understand that was given to him at this September 8 meeting.
And at that meeting, he was terminated, I take it.
Yeah, may I continue on with the motion?
I'd like an answer. Chief, was he terminated?
He was terminated at that meeting, yes,
Okay.
following a 2-to-1 vote.
Prior to that meeting, was he given a pre-termination hearing?
No.
Thank you.
Commissioner Crowley,
I have no further questions.
may I continue with my presentation?
It's up to the chair.
I just have a couple of things with regard to September 8th and the statement that was read. Okay, but I'm also looking at the minutes of Tuesday, September 8th, 2009. And that the chairman at that time read the statement, the enclosed statement, which was the attachment number 1, which is the one that you're referring to, okay, the motion, okay? And then the attorney states that he objects to the whole proceeding because of proceeding due to lack of due process. And then the other attorney that was there said that he will be able to grieve this. But he doesn't say anything about the fact, does he have anything to add? Does he want to speak? It doesn't say anything like that. And in fact, he read the motion, stated the motion, I can't even see that a vote was taken. It showed one that was on, who was on the opposite side, but it doesn't specifically state who was on the prevailing side if there was a motion taken. I'm not quite clear about that.
I don't think it's controverted that the motion was taken, it was seconded, and ultimately it was a 2-to-1 vote in favor of Officer Davina's termination.
But you see what I'm saying, if you refer to that well, I'm sorry, it's in the grievance book, but that's where we are right now, on that 107. And if you see personnel issues, that A, the chairman read the enclosed statement, and it refers to the attachment number 1. Then it goes on to say that the attorney objected to the whole proceeding due to the lack of process. And then it goes on to say that the other attorney that was there said he will be able to grieve it. Doesn't say anything about the fact that the individual was allowed to speak or to refute. And then it says a motion was seconded by the other commissioner. And I guess I'm looking at it now, and it doesn't even sound like there was a vote, but then it said one of the other commissioners was opposed, but that's all it says. It doesn't say anything about being afforded the opportunity to refute it. It just says at a later date you can come back and grieve it.
Well,
And that's where I'm having some difficulty, along with the other one where it's been redacted, and I would like to get the original for the ones that were redacted. Okay?
to back up if I could, this has been a matter that the union and the police department have been addressing over the past year with one another, including at the PELRB, which was done at the union's request. And I don't think it's ever been an issue that there was a 2-to-1 vote taken at that meeting in favor of Officer Davina's termination. The basis for the motion was set forth in great detail and read into the record. There was an opportunity for Officer Davina to provide whatever information that he wanted. And in taking himself up on that opportunity, Attorney Cahill made the objection about due process. Now, bear in mind, at this point, Officer Davina and the union have known for a week that this was going to relate to a termination issue. But if I could return to the motion, I think that would help us clarify what the issue was pending at the time.
When you, if I can
Yes.
excuse you, when you say that he had known for a week, are you maintaining that the employee was to request a pre-termination hearing? Or was the employer supposed to notify the employee of a pre-termination hearing?
The employee was in fact notified of the September 8 hearing.
Which is what this meeting was?
Yes, it was.
And why, so you're saying that they had a pre-termination hearing where he was given the charges, he was allowed to refute any charges against him, and that there was a decision made by the commission to terminate him after that hearing?
What I am saying, could I please just read into the record the motion? Because I think that might address most everything that you've asked about if I could. I had
Without-
started to, but...
Without getting into the,
Part of it is that.
Well, your question, the Commission's questions, and I do understand them, and I am not trying to ignore your instructions to me at all.
I understand that. and-
But what I'm saying is, when you are asking questions about what notice was the union afforded, what notice was Officer Davina afforded, the only way I can answer that, and the best way to describe it, is the written motion that was read to him at the hearing, at which time afterward, the union did have a chance to say anything it wanted, as did he, about that.
In that motion, was it a recommendation for termination?
It was a motion for termination that did reference the chief's recommendation as such. May I read the rest of the motion into the record so that you can consider it in your deliberations?
You can, and as soon as I get the sequence down, because the chief has already said that there was no pre-termination hearing.
The September 8,
I don't know if you heard me.
I do, I
Thank you.
did hear you. I'm sorry, if I was
I
looking
understand.
down, I was not ignoring what you were
That's fine.
saying.
I don't want to appear to be adversarial. I just want to know
Sure.
what the facts are
And
in regards to due process.
that's what I'm trying to get, because I need to explain to you, and why I seek to read into the record this motion, is that was information that was provided to Officer Davina in advance of the motion carrying for his termination.
Excuse me. I don't know if I quite agree with that, but would you specifically state how that was provided to him, or he had knowledge of it?
It was provided to him at the September 8, 2009 hearing. It was read into the record.
Only at that point when he got there?
Correct, that is correct.
That's the termination date.
The motion, yes.
That's when he was notified? as to-
Apparently, and is that what you're saying? That at the September 8th, that's when he saw it?
When I'm, may I please answer a question? I haven't really had an uninterrupted presentation yet tonight. What I am saying, and what I've tried to say, is simply to read in this information into the record for you tonight. That information was read into the record by Commissioner Gagnon on September 8, 2009, to your question.
Attorney Bailey, I just have to object, I'm not trying to interrupt you, except for the fact that when you misstate what I did, then I feel a little foolish sitting here and letting it continue. I did not have hands-on to this motion until weeks after the hearing. And the motion was provided to me by Attorney Higgins. I asked for it at the night of September 8th.
Where is the motion?
This is the motion right here.
I
Doesn't matter.
I asked for a copy that night, and I was told there was nothing to give me in writing. And that was the time I was also told there would be a substitute commission hearing the grievance. But we left there with no paperwork whatsoever. And how can you ask someone to respond to something that they have no notice of what's going to be said?
Is the department aware that you have to notify the employee of what the charges are that you're going to bring against them, and two, what the evidence that you have against them is?
In a normal situation, yes.
You're saying this was abnormal?
Yes, it was.
How so?
Because the commission learned information about Officer DeFina's behavior at the same time I did during the meeting on August 18th, when he was before the commission to discuss his displeasure with his evaluation.
May I continue with the motion, Commissioner Crowley?
I just don't want to get into the full motion, because it looks like the full motion has, it starts to spell out just cause.
If you would like to know the substance of what was read to the union and to Officer DeFina on September 8th, that discussed in detail the reasons for the commissioner's position, then that is found in Hooksett Police Department Exhibit 8, pages 34 and 35. If you do not wish me to read all of that, then I will respect your wishes, but to have a full understanding of what he was provided for by way of reasons, that would need to be consulted.
My question is, isn't it the commission's role to not to terminate without a recommendation from the chief, and not to terminate without giving the employee due process for, one, to satisfy Loudermill, and two, to satisfy the CBA? Because it appears to me, and I'm looking at this, and we'll save this for deliberation, but it appears to me that this motion, the employee was terminated on September 8th, and I haven't found out where the employee was given an opportunity to get a pre-termination hearing in, and to understand what the charges were. The chief has said that this was an abnormal situation that happened a month prior, right, at that meeting? And that's when the commission became aware of what the circumstances are. And they got new information, right? So what happened with the notification of the employee between the time that the commission and the police chief found out this new information, and September 8th, when he was terminated? Where's the why wasn't he notified within that time that what the charges are, that he's entitled to have a Loudermill hearing, a pre-termination hearing, and what the evidence is that the department has against him to back up their reason for termination?
What I can tell you is that the reason for termination, he was notified of on September 8, 2009. One thing we haven't covered yet in this motion is that the conclusion of it. And at the conclusion of it, it was made very clear that Officer Defina, the decision of the commission, ultimately, after he did have an opportunity to say what he wanted to say, its decision was subject to his right to grieve this decision pursuant to Article 25 of the Collective Bargaining Agreement.
I think that's where they erred, to be honest with you. I think what happened was that they needed to have had a hearing, a full evidentiary hearing according to the CBA and step number 3 that allows him to come forward. And then if they want to decide to terminate based on what they've heard at that hearing, then they're allowed to terminate.
And what I would say to you, Commissioner Corley, is that they did envision that Officer Defina would be able to grieve this decision and as he is trying to do now.
But they can't do that. He can't do that after he's been terminated by the commission.
He can do that. That's subject to the grievance procedure of the collective bargaining agreement, and that's actually what one of the grievances is, that is to be before you, whether or not there was just cause for his termination. And I know you have asked that we not discuss the reasons for just cause in this proceeding.
Can you show me where in, and I'm not being disrespectful, I want to see it. In what step does it show that the police commission can terminate?
As I said at the outset, I referred you to the statute that you...
Where in the CBA does it say, the collective bargaining agreement say that the commission
Yes.
ultimately terminates?
That was something that we were trying to read into the record earlier under Article 18. We have a statute that applies to you where you have the right to hire or fire.
Understood.
We have an AO that applies to you that you have the right to immediately fire as the police commission.
Understood.
What the collective bargaining agreement provides, which you did not wish me to read into the record, was that for purposes of what is that discharge has to be supported by just cause, and under the collective bargaining agreement that the parties agreed to, including the police department, that defines just cause as what the chief shall determine as unsatisfactory performance or misconduct.
And so where in step, is that step 3 that we're talking about?
What?
That happened on September 8th
No.
with his termination?
No, the September 8 motion made that process subject to the grievance procedure. And in fact, the grievance pending before you concerning just cause that you asked to defer, that is the step 3 grievance process. It has gotten more due process than the collective bargaining agreement requires. He's had an opportunity to be heard on September 8th, and he does have an opportunity to be heard before this commission concerning whether or not Article 18 has been violated concerning just cause.
But if I read step 3 correctly, if the grievant is not satisfied with the disposition of the grievance by the chief of police, or if no decision has been reached within 5 working days after filing with the police chief, the grievant, together with the union, may file the grievance with the police commission within 5 working days after said grievance was filed by the chief of police.
And what has happened in the process, Commissioner Carolian?
Yeah.
Is following the September 8 motion, which was seconded, voted on, for Officer DeFina's termination, which was always subject to the grievance procedure. Officer DeFina, as we've seen, did file 2 grievances. They are now pending before this commission.
And what I'm getting back to you about, and we'll discuss, is the authorization for the police commission at that point in time to terminate that employee without having gone through the proper grievance step.
It sought, the commission sought Chief of Graphiotis's recommendation, consistent with Article 18, and it has a statutory right to terminate employees. If the commission has evidence brought to its attention, as it did on August 18, it does have the right to terminate by statute, and it did so here, we say, consistent with the collective bargaining agreement.
What part of that is what I'd like to know?
Sure.
Where do you say that, where's your argument that that's where they're allowed to do that? What step?
The step, this is a situation that is unusual.
Regardless of unusual, the chief has the right to take a badge and gun away from somebody for something that's egregious and take that person off the street. I'm not questioning that. But there's nothing in here that says, under unusual circumstances, can we bypass this? There's nothing that allows the police commission, and if the police commission erred back then, so be it. That's where we're at now. And I don't see in this procedure, step 1, 2, 3, or 4, where we're at with the police commission and terminating Officer DeFina at the right time. After they have a hearing, he's got to have a hearing, then they can terminate. They've got all the right in the world to terminate as long as it's a just cause. Yes, I agree with you.
Thank you. And where we are right now is that that motion on September 8th was subject to the grievance procedure. The grievances were filed, and right now, those grievances are pending at the commission level. So that grievance process, we do think, has been followed here.
Can we go back to the fact of the unusual circumstances? Can I ask you, Chief, what was so unusual about that that caused it to be an unusual circumstance that it was done in that fashion?
I would say the facts, without getting into details, the facts that are contained in the September 8th Police Commission motion.
And I would ask, again, if the commission could please read that motion in its entirety in its deliberations, even if it doesn't want me to read it into the record in its entirety here. It does set forth the commission's reasoning and why it acted as it did.
I understand that, but if their reasoning and their actions were flawed, then we have to go with due process. And if they should not have terminated him at that point in time and terminated him after due process, we probably wouldn't be here right now.
Well, Commissioner Carolian, I do ask that you keep an open mind. I have not been able, in my view, to put this situation in as much perspective for you as I would like, because I understand that you want to not talk about background information. But certainly the motion that was made contemplated all along that attorney, or pardon me, Officer DeFina would have, not only on September 8th, but going forward in the grievance process, have a full and fair opportunity to talk about termination and why he felt there was or wasn't just cause for it. And that, right now, I understand you have decided not to hear that matter until the procedural issue is addressed, but that is now pending before you. I think I have talked with you as best I can about the issues that happened on September 8th, about the motion. If you don't want me to read that into the record, I do ask that you consider it. Certainly, if Officer DeFina or the union thought on September 8th that they needed more time, or that they needed some other situation to further address the information that was being read to them, we believe they did have that opportunity. We believe they did have the opportunity to say what they wanted to. The due process argument was made. And we do believe that ultimately Officer Davina has been afforded all the due process required to him, including under the contract, and he now has an opportunity to go before you and talk about just cause. The other issue that's part of the grievance that has been stated before you, and I tried to review that grievance with you, does require you to reinstate Officer Davina. I would ask that if you are inclined to address the due process issue, that you defer any analysis concerning whether reinstatement is warranted. And why I ask that is because before you can order reinstatement, I think it's very important that you do understand the issues concerning Officer Davina's performance that you've asked me not to address tonight. So I would ask that there be a deferral of any analysis of remedy if you are not inclined to hear the evidence that would go pro or con for his reinstatement.
I'd like to comment because this is a public hearing, and this is starting to become a cloud of this unusual behavior, and people's minds go crazy. Let it be known that although due process was not given to Officer Davina, he worked up until September 7th in a cruiser and was evaluated every day, and there were no problems. So I don't want people hearing this thinking that some egregious, horrendous act took place. At any time, they could have notified Officer Davina and the union that they had charges pending and set forth a pre-termination hearing, and that wasn't done.
And Commissioner,
Just a second, please.
Where? Yeah, that needs to be addressed, if we can get the original. We need to get the original on that. On that, I think we can pass on.
Sorry.
thank you. I started to interrupt you, I apologize. I would simply ask that if the police department is not allowed to talk about performance issues or issues concerning Officer Davina, that the same rule applies to the union. So I would appreciate that courtesy.
Thank you.
Thank you very much.
Yeah, we'll take a recess.
I believe we're going to take a recess, about 15, 20 minutes, around 10 past 8, will be.
10 past 8 or 10 minutes?
Okay. Does the union have anything else they want to say before we go to,
I just want to reiterate the,
please, I'd ask everyone to,
if you find that due process was not afforded and he was unjustly terminated, the union would ask you to please reinstate him. He's been out since September 8th, 2009. He was not afforded due process in any measure, and that's exactly why we went forward with the unfair labor practice. We objected to this, to the replacement commission, whatever you want to call it. And I'm very pleased to see that the substitute replacement commission is not hearing this case, but the actual commission.
well, we're not going to go there, okay? We're not going to talk about that.
But as far as reinstatement, I would say that if you do find that due process was not afforded, that just like any other proceeding before a quasi-judicial, we wouldn't even get to the next phase, which would be, you can't be dragging someone into court without a warrant or without a charge, and then while they're there, discuss their life and see if you can find something.
I understand that, thank
Point
you.
taken.
Thank you.
Could I?
Yes.
Just one.
Thank you. Again, we would ask that no decision be made on reinstatement. You have indicated the way you would like to proceed in this matter. I appreciate that. But in order to evaluate whether reinstatement is an appropriate remedy, you do need to understand the evidence. And that has not been provided tonight at your request. So we do ask that you not make any decision concerning reinstatement because you simply have not had the background information to help you to that decision.
Thank you.
Thank you.
I got a quick question, Attorney Bailey. Are you asking us that if we were to find that there was no due process, that we were to set that aside and then go forward and hear the rest of the case?
As I understand it, Commissioner Caroli, and this is my understanding of the union's grievances, what they have indicated is that if there is a finding of a violation of Article 18 due to a due process issue, that they would believe the remedy would be to have a hearing before this commission. So I would ask that, particularly because there's no evidence that has been allowed concerning issues directly related to reinstatement, that no decision about reinstatement be made at this juncture. You've not taken in any evidence concerning that. You've not been given information directly relevant to that. And we do ask that that decision be deferred.
But you're in agreement that we've heard evidence in regards to due process issue?
I believe, yes, and may I explain further? I believe that there is a potential for confusion as a result of the presentations tonight. I would have liked to have put things in better context for you so that you could understand these due process issues a little bit more. But I understand that you have tried to confine the proceeding to issues related to due process. And my point is, having done that, necessarily you have excluded all evidence directly related to reinstatement. So I know that if you're making a decision about reinstatement, you would want to be fully informed, fully educated, have the facts before you. I'm asking that you defer a reinstatement decision until that time can come. Thank you.
Thank you.
Ada?
Yes, we're going to recess until a little bit after 8 o'clock, probably around 8:05. Okay. We're at the portion of this grievance hearing where we need to debate whether or not due process was afforded the grievant. And we're going to debate in public. The simple reason is that the grievant has asked that the hearing be held in public, and therefore, according to the right to know law, that any deliberations that take place need to take place in public. So let's begin.
Want to go first? How we're going to deal with this?
Well, as I just said, we need to decide whether or not, indeed, the officer has been afforded his due process based on what we've just heard, whether or not that has been met or it hasn't. And I do have a couple of questions, or I do have some concerns that I would like to relay with regard to this. And it poses somewhat of a problem to me, and perhaps we can take that up. And I'd like to know what you think about it.
About what your issues are?
One of the issues.
What is it? What is the issue?
When the presentations were being made in Exhibit 11, in reviewing the minutes of that evening, on the second page, there's a section of it where the minutes have been redacted. And I'm very curious as to what has been left out, to the point that I think some important information we're not being made aware of, and I certainly would like to have that information. And I guess, I don't know, perhaps we ought to consider seeing if we can get that information, or getting the original set of minutes from the August 18th, 2009, to find out exactly what's missing.
I mean, I'd like to know why it's redacted, obviously. There seems to be a section that where we have, this is the meeting of the minutes of August 18th, 2009, the non-public session, correct?
That's correct, and that was the meeting where the evaluation was discussed. And on the second page, there appears to be a section that has been redacted, and like I say, I'm really concerned that it relates to this, and I certainly want that information.
Before a decision is rendered, or your opinion is rendered?
Right.
In regards to
Right.
whether there was due process or not?
Right. That's one of the questions that I have.
I don't know why it's redacted to begin with, unless it has something to do with somebody other than Officer DeFina. If there was another member or an employee, this could be the only reason I would see as to why there'd be something redacted and eliminated, when up above it talks about, I mean, was given.
Mike, please.
We'll try to play ping pong with this here. Sorry about that. I'm concerned as well as you in regards to why it's being redacted, unless it has something to do with another employee that has nothing to do with Officer DeFina. But yet, in here, it clearly, it's not redacted about the evaluation for termination. I don't know how that would play into whether there'd be due process or not. Again, without knowing exactly what it is, I'm trying to imagine how it would impact the due process.
Well, in reading over these minutes of August 18th, there's a part of the discussion that goes to the effect of the evaluation for termination. And like I said, as I read down, it just doesn't paint a complete picture. And like I say, then to have it all of a sudden redacted, I guess it's important to me to know what that specifically states there.
Do you think that something that could possibly be in there that would help you decide or make a determination as to whether due process was given or not, based on everything that we heard from both sides here, based on what we heard from the police department as well as what we heard from the union?
In some ways, yes, but in the other, I think that it also probably speaks to the fact that that something was determined that evening, unbeknownst to us, so.
I take into account what I had heard, of course, about what is said to be due process. One argues that it's due process is being done. The other side argues that it's not due process, but we can't get away from the facts of the questions that were asked by us on both sides during their offer of proof. we can't get away from the fact that it appears that on the September 8th meeting, that the employee wasn't given due notice in accordance with, following the due process requirements about, at least from what I heard, I didn't hear that there was a letter stating what the charges were, what were being brought forward, what the charges were, that the employee has a right to go forward and have a pre-termination hearing and get to refute any of that. It's, from what I'm hearing, and what I've heard tonight is this was condensed into September 8th, where he was notified by the chief that there was going to be a non-public session. He wasn't told, excuse me, he wasn't told what the charges are. He wasn't told what the evidence that the chief and the department was going to bring forward against him to uphold their just cause termination, and to, try to say that it was done all together on September 8th doesn't afford the employee time to look at the charges, notify, and try to refute what's going on.
I agree, and I think you can clearly see that in the minutes of September 8th, that that didn't happen in a manner that it normally would. So I think you're correct about that.
I mean, there's a culmination of things. I mean, this goes back to, the notes that I have is, this goes back prior months in regards to him not being, in regards to them believing that they have just cause. And what I look at is, if they thought that there was just cause back then, and it was so egregious, why wasn't it acted upon then, as opposed to coming down to September 8th?
Right.
Because the minutes show.
And not giving them prior notice that at the September 8th meeting.
It's my understanding that you need to notify the employee with a letter spelling out what the problems are, spelling out what the charges are, what you're telling them, this is what you plan on doing, that you plan on terminating, that they have the opportunity. To me, it's the employer's responsibility and duty to notify the employee, and it's the employer's duty to know how to terminate someone, as opposed to the employee knowing how to be terminated.
That's correct.
And to me, that's I think is a very, very substantial issue.
And I think when they speak about the fact that this was an unusual circumstance, that perhaps indeed, this certainly was a departure from that.
If the circumstances were so unusual, I think the process could or should have gone in a different way. I don't think that at that time, the commission should have terminated without affording the employee due process, i.e. a pre-termination hearing and a hearing in front of the commission. And if there's just cause, then terminate. But to come up with this information and then the commission deciding over what the chief may have recommended in the past, and he indicated that there was new information to him that came out. Well, I look at it as it's incumbent upon them. They're the ones that are bringing the action against the employee. The employee's not bringing the action for termination. And termination is a serious thing. It affects not just the employee, but it affects a full range of other people, including it affecting the employer. Because now the employer is going to be down an employee, so.
I guess at this point, what do we want to do? How do we want to go about this? I guess for my comfort level, I'm a little bit apprehensive before we issue any kind of an opinion on this, is to get those minutes. Are you in agreement with that, or what?
I think to err on the side of caution here, and to satisfy what you want to do, then I would say, let's get that non-redacted portion of those minutes of those meetings. I don't know, I can't think of what would be in there that would change the lack of due process, in my opinion, but in order to satisfy your wanting to look at it, I think that we should get a copy of that, and that will satisfy you. And it would be fair to both sides, I think, that we look at that redacted, and if it has nothing to do with this, so be it. If it has something to do with it, and it weighs it differently, so be it. But up until this point, maybe we should reserve our decision until tomorrow, when we find that redacted portion, and then make a decision then.
Okay. So basically, what you're saying is that we'll reserve, you're in agreement to reserve giving our opinion on the due process until we get that information about the minutes, the redacted portion, and then we'll go from there.
As much as I hate to delay this another day, I think we probably have to. And as long as we don't get into the just cause aspect of it, if we just look at the redacted, deliberate in public again regards to the redacted portion, and if you have other views or other thoughts about it, then we can do that during deliberation. Or
Okay. I guess the other reason is these are non-public minutes, and if these minutes did contain something about, or somebody else that was private, they certainly would have been, held private. So I don't know, but that's where I'm more inclined to go.
I mean, at this point, I mean, I'd like to ask, at this point, I'd like to ask ask the chief if he knows what is in that redacted portion, and if he assures us that it has nothing to do with the Defina case and has to do with something outside of that, then maybe we can move forward. If he knows that there's something else in there that's been redacted and has not been provided to the employee, then that's a different story.
Well, the chief is here right now. Chief, could I ask you?
I do not know what's contained in that redacted area.
Okay.
Do we know who forwarded this information, this copy, and who redacted it? Do you know?
I do not know.
Attorney Bailey, do you know?
Excuse me. My understanding is that that exhibit, which is offered by the union, was something that both the union and the police department admitted as a joint exhibit at the PELRB, so I didn't prepare it myself. Perhaps, as you've suggested, the best way to confirm this is to, as you have sought to do, to look at the unredacted copy. That way there's no room for misunderstanding.
Attorney Cahill, do you know what was in there, without giving the specifics, do you know what was redacted there, or did you receive this redacted?
I received it redacted. I have no idea. And my only concern about putting this off is whether or not the tape still exists and there is a non-redacted copy even available.
I understood. That was August 18th, 2009. Chief, do you know if the minutes in regards to this non-public has been preserved?
Francine's the custodian of the minutes, so she would have those minutes.
And I'd ask you, Francine,
Non-public minutes are not recorded.
Okay.
but you have the original sets of minutes?
The original typed minutes, I do.
Question. Do you know who redacted this?
I don't, unless looking at it, I don't know who redacted it.
Well, there's a section here, I mean, both sides understand it, so if you're the keeper of the records or the keeper of the minutes, how would this get redacted if this gets sent out to the attorneys for Defina? Do you know how it would get redacted?
I don't.
I think perhaps any original minutes would be with the Hooksett Police Department, as they should be under the right to know law. And again, this was an exhibit prepared for the PEORB hearing. I was not a part of that. But again, I would suggest that perhaps the best way to address your question is to look at the minutes that are maintained at the police department.
If there was something in here, do you think that would change or help you form an opinion? It would have to be something that would be fairly
Material, right.
out of scope of what has been already offered. I mean, proof has been offered from both sides, and I've heard, the evidence from one side, I heard the evidence from the other side. I can't imagine what is redacted would have an impact on the due process aspect. It may have an impact on the just cause, that if there was something that was spoken to about just cause, but for due process purposes of whether the employee actually received what he was supposed to receive, I can't imagine anything being redacted that would make a difference.
I guess my only concern is when I look at these minutes, if it were a case simply of, it being about someone, or there would be no need to redact them because they're non-public minutes. The fact that something has been redacted, there's a reason for it.
But they would have to, if it was about another employee, or if it involves someone else that is not involved with the Defina case, they would have to redact it because it's non-public minutes, and if they're giving it to the Defina attorney and Defina in regards to his case, then they would have to redact if it involved another employee, because they still have to follow RSA 91, which would come into play for that other person. But so far as the evidence that's been presented, I think is really clear cut. I mean, I specifically asked the chief questions about was there a pre-termination hearing. He answered no.
Right.
That weighs, heavily. We talked with Attorney Bailey and got the sequence and developed information from that. We talked to Attorney Cahill and got information like that, but the timelines don't go away. The timelines are still there, in my opinion.
I agree with you that the timelines are still there, but if you look at this and you read it, you just didn't go in there and put some information about some other employee. There's clearly something missing there. You look at it and look at it carefully, you can see that there is something there missing. It's not, if you were talking about another employee, there would be some other discussion about something else being brought up, and there clearly isn't. That's where I stand.
Okay, who would have the authority, chief, to redact this portion and send that out to the defense, so to speak, the Defina side?
again, not knowing how they were prepared, if we were providing those to an attorney to prepare for some type of hearing, that attorney would then take what we provided them and format them properly for the venue that they were going forward.
Okay. Attorney Cahill, you received this from the Hooksett Police Department?
That's affirmative.
Thank you for standing up, because we can't always hear. So if somebody asks a question, if someone needs to answer, would you please stand up, because they're not capturing it?
I don't change anything. All my exhibits are from the department. The only thing I did was add a page number. But if I may, if something is missing from there, I don't see how it could do anything but either be held to due process clause, held to due process violation, or it would just be part of the just cause situation, which we're not talking about.
Attorney Bailey, did you redact this and send this forward to the PELRB?
No, as I explained, I was not part of any proceeding before the PELRB. And as I've said, if you do have a question about the minutes that you feel you need to address before you make a decision, then I think the best source is to consult what is on hand at the police department. If, as Attorney Cahill says, you feel that you can proceed without that information because you feel you have completed your analysis, then I guess you can proceed. But I think the best source of information is where they are maintained at the police department in the normal course of the 91A.
Okay. So if I understand it correctly, Chief? You did not send this out forward. Francine is the keeper of the minutes.
Correct.
She did not send it forward to Attorney Cahill. And Attorney Bailey didn't, you didn't, and he didn't, and she didn't. And I apologize for making it sound trivial. We need to know who did.
The department would have sent it out to the attorney that put together the paperwork, the presentation for the PELRB.
All right, and do we know who that attorney is that put together that presentation?
Attorney Higgins,
Attorney
representing the
Higgins.
department at the PELRB.
All right, and Attorney Higgins also represented the department or the police commission in the termination of Defina.
Correct.
Are you saying that the attorney that made the presentation to the PLRB had not only the ability, but was able to redact those minutes?
You would have to ask him that. We don't put that together. The attorney put the presentation together for the PELRB, but please keep
But
in
if
mind that the
minutes were
hearing.
redacted, don't you think you would have knowledge of that?
I wouldn't know. The attorney would be putting together a public presentation for the PELRB.
Okay. If this was presented to the PELRB, which has absolutely nothing to do with Officer Defina's termination, why would this non-public session that specifically goes to Officer Defina's termination, why would that be sent or given to the attorney that is going forward in front of the PELRB in a redacted form? And when you say going in front of the PELRB, you're talking about going in front of the PELRB on the matter that Defina went forward with, going up to the PELRB?
That is correct. And again, I think that the best source of information, should you decide to look at this, would be how these records are maintained in their original form at the Hooksett Police Department. I'm just trying to explain that this information, as it appears before you, was in the form that it was submitted as an exhibit at that PELRB proceeding. So if you have a question about what those materials look like in their original format, then I think the best source to consult with would be the Hooksett Police Department, where they are housed, as you would normally maintain records.
Are we ready to start?
Hmm?
Are we ready to state that? That's,
If you feel more comfortable getting that information, and if you feel that if there's something in there that may assist you in your decision-making process, then it would be wrong for me to not allow us to look at that or take that into consideration and afford you the opportunity
right.
to settle it in your mind. So I'm in agreement with you that let's look at these minutes, see what's in there, and if there's something that's going to change the due process, then we'll be doing our due diligence, I guess.
Okay, I think we're very, very clear, or we more or less agree on that point, that before we can go forward and arrive at a decision with regard to the due process, by tomorrow evening, we need to have a copy of those original minutes that are unredacted to make sure what is stated there. And I understand what your concern is, but in order to do our due diligence, I think we have to ascertain that. Yes, go ahead.
And if by chance, because I got those from Attorney Higgins, I think this is right on top. If they cannot be found, are we still gonna move forward?
I guess.
Are you saying if these minutes cannot be found within the commission files for non-public minutes? If they're missing?
It's something that Officer DeFener and I have no control over,
Right.
and yet it could hold up a decision. So
Right.
I'm saying that, although I agree with you, make sure you're comfortable with due diligence and making sure that you have all the information you need, but if through no fault of the employee who's been terminated, you cannot get these by tomorrow night, are we still moving forward?
I would say yes.
I think we're gonna be ready to, yes,
Thank you.
yes. Okay. I think that's it for this evening.
I think so, so we'll reserve.
Yep, we'll resume again, the grievance hearing again tomorrow evening, and the meeting will start at 7 o'clock. The hearing will start, not the meeting. The hearing will start at 7 p.m., and we have until 10 p.m. This is not a regular meeting where we're taking input or questions, okay?
We're going to adjourn until tomorrow.
Tomorrow, yes, we're going to adjourn this meeting.
This is a regular meeting?